Good afternoon to you all. I'm Dr. JP Singh, continuing our lecture from the previous one. This is part 2 of the same lecture on medical negligence. So in last lecture, we discussed paternalism, therapeutic privilege, and the patient autonomy, the complete patient autonomy. Moving ahead, we'll discuss medical negligence and the tort. So what is tort? Tort is it's derived from Latin word means twisted, which is a civil wrong that results when a defendant engages in conduct that harms another person. Here the defendant is physician or the doctor, and another person means patient. Right? Here the tort is a civil wrong that results when a patient or when a physician engages in conduct that harms the patient. And in tort claims, the suing party, again the patient here or the plaintiff, asks for the monetary compensation, monetary damages from the defendant, means from the doctor, to compensate for the harm suffered. So the patient, he asks for monetary compensation from the doctor in tort. Medical malpractice, all medical malpractice cases in which patient demands compensation are under tort cases. These are under tort cases, right? So negligence, what is negligence? Here, by asking for or by describing negligence, we are discussing medical negligence. It's the omission to do something which a reasonable man or a reasonable physician in our case, guided by ordinary consideration, which ordinarily regulate human affair. Or here the reasonable man is physician and human affair means the medical ethics or etiquettes would do, or the doing of something which a reasonable and prudent man would not do. Something which a reasonable man would do here or would not do. So there are two types of negligence: by act of commission or by acts of omission. By act of commission means doing something which was not supposed to be done, which was not supposed to be done. Or act of omission means doing something which was not. Act of omission means not doing something which was supposed to do, not doing something. Yes, this is writing error. Not doing something which are supposed to do. Now professional negligence or medical negligence in toto. Professional negligence or medical malpractice, it's the absence of reasonable care and skill or willful negligence of a medical practitioner in the treatment of a patient, which causes injury or death of the patient, right? It's a absence of reasonable care and skill or willful negligence of a medical practitioner in treatment of a patient, right? Another definition which we can say is doing something that one is not supposed to do, means act of commission, which is not supposed to do, act of commission, or failing to do something that one is supposed to do. Supposed to do, that means act of omission. So it can be described by 4 Ds of negligence, which are duty, dereliction of duty, direct causation, and damage. Now we'll describe each one by one. So firstly, duty. Duty, the doctor began to owe a duty towards the patient. Firstly, when the patient or when the doctor agrees to treat the patient. When he agrees to treat the patient first, and second, in all emergency cases, there is always a duty of the doctor towards the patient. And in such cases, doctor-patient relation between the doctor and the patient is established. Where there is no doctor-patient relation, there is no duty towards the patient. Then there is dereliction of duty. The word to pay attention is dereliction of duty. Once the presence of duty has been established, after the presence of duty has been established, there has to be a dereliction. Or what is dereliction? Means negligence, willful negligence. There has to be dereliction of duty on part of the doctor. That means the doctor should have been negligent, willfully, knowingly in performing his duties toward the patient. The physician must conform in such cases to the standard of a prudent physician under similar circumstances. If there is no dereliction of duty, then in such cases, in normal circumstances, the physician must conform to the standard of a prudent physician. That means what he'll do normally in such cases, that is a prudent physician, right? The failure on the part to behave like a prudent physician or to maintain applicable standard of care means it leads to dereliction of the duty. The failure on the part of the doctor to maintain applicable standard for care and skill in that case leads to dereliction of duty. So next is the damage. Next is the damage caused. The damage must occur as a result of dereliction or as a result of willful negligence, and it must be foreseeable. That means the doctor or the patient can assess that something wrong is going to happen, and even after that, they are not taking any precaution. Even if another contribution to this damage, if doctor is negligent, in that case, the patient cannot sue the doctor for compensation if no damage has occurred. In cases where there is dereliction of duty, but there is no damage, when there is no damage, the doctor cannot be sued for negligence. And examples are aggravation of a pre-existing condition by the doctor by his dereliction in duty leading to damage, diminishing the patient's chances of recovery, expenses incurred on the management of patient as a result of dereliction, and the damage is occurred in form of monetary loss. The pain and suffering they have increased, and it is another form of damage to the patient. The loss of earning due to absence from work by the act of omission or act of commission by the doctor. So the patient is not able to attend the work and there is loss of earning. Then there is loss of potency on the patient for males or females. Then prolonging the illness. Again, the individual or the patient is absent from the work, loss of earning, then reduction in expectation of life, and finally, the death of the patient, the form of damage caused to the patient. Then direct causation. Another is direct causation. First was duty, then dereliction, then damage, and last is direct causation. 4 Ds. These four should be established, then only negligence can be contested in court. The damage which has resulted, it should be directly from the dereliction or from the willful negligence of the physician, or it should be the proximate cause. The most proximate cause for the damage should be the dereliction of the doctor and not from any other cause. The proximate cause is a cause which is natural and continuous sequence, unbroken by any efficient intervention, causes and produces the injury, and without which the injury would not have occurred. Without which the injury would not have occurred means it is the whole and complete. only reason for the damage is caused. Right? When these four criteria are fulfilled, then there is a fit case of negligence. Examples are patient come to the doctor for treatment, doctor demands his fee. For we are explaining duty here. Doctor demands his professional fees, patient is not able to give, doctor refuses treatment, patient does not take treatment from elsewhere, and after some time the patient suffers severe injury, and in such case patient cannot sue doctor as there was no duty. Another example of duty you can read here. Then there is dereliction. The cancer patient comes to the doctor for treatment and the doctor agrees. That means duty is established. There is doctor-patient relation here. Doctor-patient relation here. Then there is dereliction of duty. The doctor gives proper and judicious treatment. However, the patient dies. The patient cannot sue the doctor in such case because there was no dereliction, because he acted as prudent physician in this case, the present case. Then damage. Patient of viral fevers come to the doctor starts the treatment for tuberculosis. Being there no sign or lab report for the tuberculosis, hence the dereliction. After the patient becomes well, he comes to know that doctor has given him wrong medicine or wrong treatment. The patient cannot sue the doctor because there was no damage. And last is direct causation. Patient comes to the doctor with lacerated wound. Doctor agrees to treat him. Duty is established. First, doctor fails to stitch the wound, dereliction. Afterwards, the patient goes to quack, who applies something over it. The patient develops infection, damage. First is duty, second is dereliction, third is damage, and the patient sues the first doctor for not stitching. He cannot sue because there was duty, there was dereliction, and there was damage, but the damage was not the direct cause or proximate cause. Proximate cause, right? So the damage should be due to the proximate cause, direct causation by the physician. So what is the difference between professional negligence and the professional misconduct? Main is the duty of care towards the patient. Doctor must have a duty towards the patient which is neglected in professional negligence, whereas there was no such duty. There was no such duty by the doctor towards the patient, and though the doctor may be accused for professional misconduct in the absence of such duty. Damage to the patient must be present here. It must be present here, and damage may not be there, but there is professional misconduct. Trial by the civil or criminal code. Here there is no code, but the council, the medical council or NMC or state medical council. So the complaint in professional misconduct, if the patient feels there was professional misconduct, the complaint is made to the national council or state council. And the punishment here is imprisonment or fine, and punishment here is warning notice or penal erasure, and there is appeal in higher court or to the state medical council in professional misconduct. Then types of negligence. There are four or five types of negligence. First is medical negligence, patient negligence, contributory negligence, composite, and corporate negligence. We'll study each one by one. Civil negligence. Civil negligence means when the patient demands monetary compensation for the damages. Whenever there is demand for monetary compensation in lieu of damage caused, then the negligence is civil negligence. It comes under tort law. Civil negligence is covered under tort law, and when patient refuses to pay the fee, when in the opposite side, the patient refuses to pay the doctor's fee alleging negligence, doctor can bring the civil complaint against the patient to recover his fees. the case either goes for civil court or the consumer forum. Any place, the complainant or the patient can file his complaint, and the punishment is the doctor only has to pay compensation as decided by the civil court or the consumer forum, and there is no criminal liability. There is no criminal liability for the doctor, and he cannot be sent to jail in civil negligence. Whereas in criminal negligence or criminal malpractice, the patient complains to the police. So whenever police is involved, it is criminal negligence, right? And regarding the misconduct of the doctor, and the police registers a case against the doctor. And in this case, who fights the case? Here, the state or the government will fight and not the suffering patient. Whereas in civil negligence, patient himself fights the case against the doctor, and the two parties in criminal negligence are state versus the doctor. Punishment is in form the prosecution under the various sections of the IPC. If found guilty, the doctor is liable to pay damages as well as sentence. Here both monetary as well as social loss to the doctor. And in such case, standard of proof which is required to prove the guilt is beyond reasonable doubt. It is beyond reasonable doubt, right? And the conditions to be satisfied are indifference to an obvious risk. The risk was there for the injury or death of the patient too, but there was indifference by doctor. Actual foresight of the risk was there, but the physician continued the same treatment. Appreciation of the risk and intention to avoid it was there, but the doctor showed high degree of negligence in attempted avoidance. That means by actions of the physician, there was no attempt to avoid the negligence. And last is inattention or failure to avoid a serious risk which went beyond mere inadvertence, in respect of obvious important matter. So, not paying attention to the patient when the risk was foreseeable and not putting enough intervention on right time. They are under criminal negligence. So, this slide shows the civil negligence and the criminal negligence. Doctor-patient relation, negligence occurs, patient suffers injury. The injury was maybe minor or gross. The patient may go for compensation from the doctor, or the patient may file a complaint in the police. Right? In both cases, injury is gross or injury minor, compensation or police complaint. If he goes for the compensation, approaches the civil court, and civil court, the approach by the patient to the civil court is generally in case when the treatment is given free, such as government hospitals or the camps offered by the doctors or some corporate hospitals, or when they approach the consumer court in case the fee was paid, or they are going to some civil doctor or corporate hospital. In such case, they go for some consumer court. And when the police complaint is filed, police brings the action against four IPCs. First is 336, when there is no injury, but the doctor endangered the life of the patient. 337 IPC, if hurt was there. 338, when the hurt was grievous in nature. And section 304, if the death was caused due to rash and negligent act not amounting to murder. 304. So IPCs are 336, 337, 338, and 304A IPC. So what are the difference between the civil and the criminal negligence? It is not a, there is no absolute or watertight differentiation. The patient can simultaneously, that means one patient can file the complaint both in civil court as well as to the police. And same case is going to both civil and the criminal court. And in such cases, the same negligent action of the doctor would be civil as well as criminal in nature. That means compensation in form of money, monetary, or punishment to the doctor. The difference between the two thus depends on patient sector action. That means he is going to civil court or consumer forum, or he is going to police, or he is going to both. So the difference between civil negligence and criminal negligence. What are the difference? Here the damage to the patient is generally minor and patient was unable to attend the office such form, and the damage to patient is generally very gross is criminal negligence. Action of the patient brings suit in civil court for monetary compensation, and patient files here in criminal negligence, patient filed the complaint to the police. The complainant here is patient and complainant here is state. That means against the doctor, state is fighting, and against the doctor, here patient has complained to the civil court. And then prosecuting lawyer is engaged by the patient himself, and here as the government is going against the doctor, so the public prosecutor he is fighting against the doctor. The case is cited as patient versus doctor, and patient versus doctor versus the state in criminal negligence. It is tried as discussed in civil court, here criminal court. The court may ask to pay monetary compensation and no imprisonment is given in civil negligence. Here, fine plus imprisonment in criminal negligence, right? So, next is patient negligence. It is outright negligence by the patient only. It is one form of defense for the doctor in negligence, medical negligence cases where there was outright negligence by the patient and doctor is not liable in such cases for the damage caused. Examples are patient is not giving correct history or taking an alternative form of treatment without informing the doctor or not following doctor's instruction and discontinues the treatment or refuses to take the treatment for the mentioned duration or leaving the hospital without the advice of the doctor. These are example of patient negligence. Then there is contributory negligence, which means both doctor and patient they are negligent for the same case or damage caused. These are the example: the doctor applies tight plaster. By doing so, he is negligent in his action, and patient develops the numbness, does not inform the doctor, whereas he was instructed, he was asked by the doctor, if there is something going wrong with your limb, you should report. And as a result, patient suffers the injury. Doctor is entitled to the defense of contributory negligence because he has already informed that if there is something happening with your limb or the plaster, please report back. And doctor prescribes a drug. Another example, he fails to inform the patient for its side effect. The doctor is negligent. Patient starts getting the side effect. He fails to inform the doctor and suffers the injury, contributing to the negligence. Please neglect this statement. In this slide, various situation. Doctor is negligent in his action. Patient is not negligent. In this case, first situation, patient suffers the harm. It is medical negligence by the doctor, right? But if both are not negligent, this third slide, doctor is not negligent, patient is not negligent, then it is patient negligence. In both cases, the harm is to the patient, but in one case, doctor is negligent, in another case, patient is negligent. Whereas in third situation, both doctor and patient are negligent about the medical situation. This is contributory negligence, right? So first is medical negligence, second is patient negligence, third is contributory negligence. Then there is composite negligence. In this, when a patient suffers injury as a result of combined negligence by two or more doctors. The patient suffers harm, it is called as composite negligence. Then there is corporate negligence, means negligence of a bigger hospital. The doctor may or may not necessarily be liable in this case, and the hospital uses defective or poorly maintained equipment, retains or selects incompetent employees, doesn't keep oxygen cylinders in the ICU, and does not maintain sterile OT. These are the examples of corporate negligence where doctor is not directly involved to the damage caused to the patient, and the patient suffers harm. So here the doctor is not responsible for negligence, but the equipment from the hospital, right? So this was all from my side for today's lecture. If you have any queries, please write in the comment box and share this lecture, and please subscribe to my channel. Thank you.